Welcome to the second segment of the DOJ investigation into the January 6th attack FAQs. These build, so if you missed the first segment, please start there. Now, I'll answer the question. Why can't they charge Trump now with the evidence they have and keep investigating? Variation, the DOJ should just indict what they have now and bring superseding indictments later. Getting to the truth is a process. A number of former prosecutors advocate a strong-arm method of getting to the truth. Subpoena them all, force them to tell the truth, and throw them in jail if they don't. Unfortunately, the strong-arm method is unlikely to get you very far. The first problem: to force them to tell the truth, you have to know the truth before you start questioning witnesses, which is the wrong order of things. Through the questioning of witnesses, the truth comes out. The second problem: people can say they don't remember. Technically, it's perjury if a person says, "I don't recall," but they actually do recall. But it's rarely prosecuted because it's hard to prove, and a lot of people really can't remember details. The third problem: the Fifth Amendment is always available as a way to avoid answering questions. A hostile witness or an adverse witness is one who doesn't want to be there and doesn't want to talk. A good cross-examiner can squeeze facts out of a hostile witness, but it's hard. And if all the witnesses are hostile, you may not get very far. The idea is to have as many cooperating witnesses as possible. So now I'm going to talk about Cassidy Hutchinson's process. Cassidy Hutchinson, a White House aide and assistant to former Chief of Staff Mark Meadows, had to go through a months-long process before she was able to be forthcoming with the committee. She was one of the people in the room where it happened. In February, she received a subpoena from the Select Committee. She was 26 years old, unemployed, and had no money. Her aunt and uncle had offered to refinance their house to help raise the money she needed for a lawyer, but their application to refinance wasn't approved. When she wrote to Trump people, she was primarily seeking financial assistance. Trump World provided her a lawyer, a die-hard MAGA person. While working with this lawyer, she was not forthcoming with the committee. Then she switched lawyers to one connected with Jeff Sessions. With her new lawyer, and after she bonded with Liz Cheney, she found new courage and was able to offer the riveting testimony that we saw on television. Now I'll talk about Pat Cipollone's process. As a result of Hutchinson's testimony, Capelloni agreed to testify under oath. Previously, he resisted. The committee primarily needed him as a corroborating witness. Now, if 6 people are in the room where it happened and one testifies truthfully and the others close ranks and call her a liar, a jury may waver. But if the White House counsel is able to corroborate her story, the truth gets easier to prove in court. As Garland said, in circumstances like those of January 6th, a full accounting does not suddenly materialize. Prosecutors who rush to trial without all the evidence risk being surprised at trial with evidence they didn't know about. Sometimes the new evidence can change our understanding of what happened. For example, here's what we knew at the time of Trump's second impeachment. On December 19, 2020, Trump summoned supporters to D.C. with his "Be There, Be Wild" tweet. During Trump's January 6 speech on the ellipse, he told the crowd, "If you don't fight like hell, you're not going to have a country anymore." Then, perfectly timed for when Congress was scheduled to certify the election, Trump directed his protectors to the Capitol and said he would accompany them. Reporting at the time of Trump's second impeachment told us, basically, that about 50 minutes into Trump's speech, some of his supporters began heading toward the Capitol, where they created unprecedented mayhem. Legal scholars at the time debated whether "Be There, Will Be Wild" and "Fight Like Hell" was legally sufficient to prove that Trump incited violence, given the difficult hurdle for proving that speech incited insurrection under the Brandenburg test. Since that time, we have learned, mostly from DOJ filings, that the paramilitaries that led the attack on the Capitol were not at the ellipse when Trump gave his speech. They skipped the rally and went straight to the Capitol. And they came prepared for military action on January 6th. And they did much to rile the crowds after Trump sent them to the Capitol. Now, the head of the Oath Keepers, Stuart Rhodes, and his sidekick, Kelly Meggs, have been convicted of seditious conspiracy, which establishes the riot was not a spontaneous reaction to Trump's speech. It was meticulously planned in advance. In other words, What actually happened was a lot more complex than what we thought at first. And these new details undermine the theory that it was Trump's speech at the ellipse that incited the attack and caused the damage. On the other hand, the new facts are potentially much worse. A prosecutor who puts one story before the jury and then says, "Wait, that's not what happened, this is what happened," is on shaky ground. Prosecutors need to know what happened before they walk into court. A guilty defendant knows exactly what happened and will know if the prosecution has the wrong end of the stick. The defense can then introduce evidence at trial showing that the prosecution has the wrong end of the stick, and the prosecution falls apart. For example, if Trump had been charged in March of 2022 with inciting an insurrection, and the defense submitted evidence that the people who committed the violence were not at Trump's speech and did not hear Trump's speech, the prosecution would have looked stupid and Trump would have probably been acquitted. Because the new facts we've learned since Trump's impeachment point to even more culpability for Trump, rushing to trial right after the insurrection would have greatly increased the chances of Trump escaping criminal conviction for his role in the insurrection. Moreover, we wouldn't have even known the full extent of his role. Good prosecutors don't rush to trial before they have all the evidence and a firm understanding of exactly what happened. Now, I'm going to tell you two stories about prosecutors who rushed to trial before they had all the evidence. The first is the story of a young and arrogant federal prosecutor who was absolutely sure that he had a case against my client. Indeed, the case looked airtight. My client was caught red-handed with illegal drugs. Plus, she confessed. Can't get more straightforward than that, right? Turns out the prosecutor didn't get all the facts. The facts. My client was sleeping in the back seat of a truck. Further back in the truck were illegal drugs. The truck driver owned the truck. He was her boyfriend. He was also married, but not to her. So there she was, sleeping in the back of the truck with drugs nearby, when the truck driver drove onto an Air Force base right past the sign that said, "All vehicles passing this point are subject to search." Yes, he did that. Defense lawyer does a facepalm. The purpose of the sign was obvious. If you drive past the sign, you consent to the search. If you consent, the search is legal under the Fourth Amendment. I don't know why he drove past that sign under the circumstances. Maybe he wasn't the best reader. My client woke up as the officers were searching the truck. Her boyfriend, in a panic, took her aside and said, "You got to say the drugs are yours. If I get charged, I'll lose my job." Apparently, he was also terrified his wife would find out. So my client did it. She confessed and said the drugs were hers. She was charged with a federal crime because they were on federal property. First, I tried to talk the prosecutor out of insisting on jail time, which would have totally ruined her. She would have lost her job as a laundress. She was barely hanging on financially and otherwise. The prosecutor wouldn't budge. He insisted she should go to jail. So I thought and then finally got an idea. I filed a motion arguing that the search was illegal as to her because a sleeping person can't consent to a search. Guess what? The judge agreed with me. During the evidentiary hearing, he turned to the prosecutor and said, "I don't see how someone can come out of sleep and give consent." Winning on my motion would mean that the evidence would be excluded under the exclusionary rule. That means that evidence obtained in an illegal search can't be used in court. As soon as it was clear which way the wind was blowing, the prosecutor asked for a recess and said he wanted to talk to me. Needless to say, the case ended to my client's satisfaction. Now, had the prosecutor probed a little more and gotten the whole story, he might have seen that the case was stronger against the truck driver who owned the truck and actually consented to the search. Okay, one more story to illustrate the point. One of my clients was given a reckless driving misdemeanor for driving too fast in a parking lot. Ordinarily, things like that are not criminal, but she was going so fast, she was charged with a misdemeanor, which is criminal. So the officer had drawn a map of the parking lot showing her path and where he stopped her. We hired a professor of physics and engineering who went to the parking lot, took measurements, did the calculations, and said there was no possible way that her engine could get going at that speed given the short distance. My guess is she was going too fast, but not as fast as the officer said. We sent the calculations to the prosecutor. Some time passed. Charges were dropped. I assumed that they verified the calculations. Now, the prosecutor could have refiled the charges, accusing her of going at a dangerous speed that the car could manage. But see how that looks. The jury would wonder how the officer got it wrong the first time. Her theory was that the officer lied. Refiling the charges would look as if the prosecutor and officer were targeting this particular person. In fact, the prosecutor didn't recharge the crime. The matter was entirely dropped. This is what Merrick Garland meant when he said, "We have to get this right." Now I'll give you a few more reasons the DOJ should wait until the investigation is complete before filing charges. Mark Reichel, an experienced criminal defense attorney, said this: "Once an indictment is filed, the government cannot use that indictment to develop more discovery or trial prep. That's an illegal use of a grand jury. Because the defense can't use their own grand jury, once an indictment is made, the prosecution cannot keep subpoenaing documents and people to testify. That's why the investigation needs to be complete before there's an indictment. Also, there's a thing called admission by a party opponent. And the government is a party. The government agents all speak with one voice. So, if, for example, a federal prosecutor in one place or at one time calls a defendant a liar, and in another federal case somewhere else, the government tries to use that defendant as a witness, the government has discredited their own witness because the government has actually made an admission. So to take an example, at a bail hearing, a prosecutor may say the worst things about a defendant who's trying to get bail. Then, if the defendants later flip, the government has discredited their testimony. This is why the government, in a large, complex case, must take care in how they proceed. Also, defendants have a right to a speedy trial. So if the investigation is ongoing and the feds bring charges before all the evidence is gathered and it takes too long to get the remainder of the evidence, the case goes to trial before all the evidence has been gathered. An acquittal means it's over because of the constitutional protection of double jeopardy. A person cannot be tried for the same crime twice. So if a person gets to trial and then later stronger evidence is uncovered, the prosecution can't say, "Wait, we have more evidence. We want another try." Also, a defendant has a right to see all the evidence the prosecutor has because prosecutors can't withhold exculpatory evidence. So, if a person is indicted before the investigation is complete, the defense lawyer waltzes in, files a motion, and the defendant gets to see all the evidence already collected. Everyone else still being investigated will also find out. Among other things, this helps them coordinate their stories. When to bring indictments is part of an overall strategy. It is literally impossible for people outside the DOJ to evaluate whether the DOJ strategy is working because we don't have all the information because, remember, a central tenet of the way the Justice Department investigates and a central tenet of rule of law is that the DOJ does not conduct its investigations in public. Thank you for listening, and I hope you'll check out the next segment of the DOJ investigation into the January 6th attack FAQs.